going to get started with some introductions before we begin our panel.
Thank you all for coming. I'm Katie. I am the Programming Director for American Constitution Society, the umbrella progressive organization on campus. And I am one of the presidents of Law Students for Reproductive Justice, who is co-sponsoring this event along with Health Law Society. Thank you all for coming. This is pretty informal. We're just going to have a great discussion and hear from some scholars today. So feel free to refresh your coffee and grab snacks throughout. So today we are going to be talking about the Supreme Court's recent decision in Burwell versus Hobby Lobby. As I'm sure we all know, but just as a quick refresher, this case determined that closely held for-profit corporations were people for purposes of the Religious Freedom Restoration Act, and as such could claim exemption from providing certain types of contraceptives to their employees. This case was consolidated with a similar case, Conestoga Wood, and opened this new area of jurisprudence. So we're going to be talking about the reasoning behind the decision, the potential implications for it, and the reproductive justice aspect and religious freedom aspect a bit more generally. So today on our panel we have three of our own constitutional law scholars. First we have, well in the middle, we have Professor Dawn Johnsen, who is the Walter W. Foskett Professor of Law here at Maurer. Professor Johnsen graduated from Yale Law School and from Yale for her bachelor's. And then had a distinguished career in Washington, D.C. under the Clinton administration. She was formerly head of what is now, of the legal department of what is now NARAL Pro-Choice America. She has worked for the American Civil Liberties Union Reproductive Freedom Project. She teaches here 3 constitutional law classes, Con Law 1, an advanced con law class in the First Amendment, and our constitutional law seminar in sexuality and reproduction. She also serves on the National Board of the American Constitution Society and as the advisor of our chapter here. Professor Johnsen also assisted with the Guttmacher amicus brief in the Hobby Lobby case and has provided some commentary on SCOTUS blog that you all might have seen. So we're very excited to have Professor Johnsen speak on this issue.
Joining us today as well is Professor Konkel, the Robert H. McKinney Professor of Law here at Maurer. He is a scholar of constitutional law and more specifically theory and religion in the law. He obtained his JD from Ohio State University, where he was elected to Order of the Coif and served as the research editor for the Ohio State Law Journal. He is the author of numerous articles in the book Constitutional Law, the Religious Clauses. He has been recognized on numerous occasions for contributions inside and outside of the classroom, winning awards for excellence in teaching and contributions to the graduating classes. In addition to his appointment here at the law school, he's also an adjunct professor of religious studies at a Nelson Poynter Scholar at the Poynter Center for the Study of Ethics. He's been a member of the faculty here since 1983, teaches constitutional law, the First Amendment, and law and religion. His research addresses constitutional law and theory, religious liberty, and the role of religion in American law, politics, and public life. So, Professor Conkle, thank you for being here. Additionally, we have Professor Steve Sanders here today. He joined the Maurer School of Law in January 2013, teaching in areas of constitutional and public law. His current scholarship focuses on issues affecting same-sex couples and their families at the intersection of constitutional law, conflict of laws, federalism, and family law. He also has interests in higher education law, academic freedom, and as I learned today in his family law class, the political process theory. Sanders began his career as an administrative staff member at IU Bloomington, serving as assistant to the chancellor and assistant dean of the College of Arts and Sciences. He earned his JD from the University of Michigan, where he was an articles editor on the Law Review, received the Bates Memorial Scholarship, the school's highest award to graduating seniors. He then clerked for the Honorable Terrence T. Evans of the Seventh Circuit Court of Appeals, went on to spend 4 years with the Supreme Court and appellate litigation group Maurer Brown, and became the firm's most junior attorney to represent the U.S. Supreme Court argument in a client matter. He's represented the ACLU, the American Association of University Professors, and other groups. He's also taught at the University of Chicago and as an editor at the University of Michigan School of Law. So thank you, Professor Sanders, for being here as well.
Okay, I am going to speak first by our agreement part of this panel. I want to say we are hoping to keep our introductory comments very short so that there's time for your comments and questions, and just speak for 5 minutes or so each. I may go a little longer because I am going to attempt to summarize the Hobby Lobby decision very quickly for you and then make just a couple of my own comments about it. So I assume you've all heard about Hobby Lobby, much in the news this summer. So I'll keep the summary brief and emphasize things you might not have read in the press as much. So one important fact is, at issue is a federal statute, not the Constitution, not the Free Exercise Clause of the First Amendment. But it's useful to talk just a couple sentences about the interplay between the Religious Freedom Restoration Act and the First Amendment. So RIFRA, as it's known, the federal statute, was enacted as a response to a controversial Supreme Court opinion, the Smith case, which involved the rights of Native Americans to use, the facts involved, Native Americans who wanted to use a drug peyote in the exercise, in religious practices, and in the course of upholding the ruling against the Native Americans, the Supreme Court issued a broad holding applicable elsewhere that said if the government, if the government is seeking to impose a generally applicable law or rule or policy, such as the drug laws, and it has the effect of having a substantial burden on the exercise of religion, essentially that's okay. The government does not have to meet heightened scrutiny in order to, in this case, enforce the drug laws. Very controversial and opposed by a wide spectrum of organizations, individuals, and Congress. Passed overwhelmingly the Religious Freedom Restoration Act, which says, essentially, the government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability, unless, and here it imposed heightened scrutiny, unless it is the least restrictive means of advancing compelling governmental interests, and hopefully that standard is familiar to all of you who are at least second or third years and have taken Con Law 1. Now here I can't resist wasting one of my minutes on a slam against Wikipedia, because I always tell my students, do not rely on Wikipedia. I looked at Wikipedia for the quote of what RIFRA actually says, just to pull that out, knowing I couldn't rely on it, but this is what Wikipedia says. The Religious Freedom Restoration Act applies to all religions, but it is most pertinent to Native American religions that are burdened by increasing expansion of government projects onto sacred land. So you're never going to get a better example about why Wikipedia is sometimes so off the mark. So anyway, back to our regularly scheduled program. Okay, the Supreme Court in the city of Bernie, another important constitutional decision that you hopefully will encounter if you haven't already, about congressional power generally, said that RIFRA was beyond Congress's power to enact, essentially to apply to state governments as it sought to do, but that it still applies to the federal government. But then some states have enacted what we call mini RIFRAs, their own RIFRAs. So that's kind of the constitutional background. So at issue is, in Hobby Lobby, the interplay between RIFRA, this statutory protection of religious exercise, and the Affordable Care Act, which hopefully you're also all familiar with. The Affordable Care Act and implementing regs under the ACA essentially requires health insurance plans to cover certain basic preventive services, including contraceptive coverage without a copay. And many employers, for-profit and non-profit, have objected to having to provide contraceptive coverage, some all, some certain methods of contraceptive coverage, because it conflicts with their religious opposition to contraception. So very quickly, the four primary issues the court addressed and resolved in Hobby Lobby in a 5-4 closely divided split with the 3 women in the dissent, I'll just point out. So another thing I want to point out, Justice Kennedy, the justice in the middle on so many things, wrote a separate concurrence. He joined the majority opinion, but wrote a separate concurrence in which he emphasizes the narrowness of it, of the majority's opinion. And presumably, many commentators believe that the narrowness of the majority opinion itself reflects the need to attract Justice Kennedy's fifth vote to it. So the majority opinion is full of all these, statements about all the things they're not deciding. And I think good chance that 4 justices would have gone farther, but needed to get that fifth vote, Justice Kennedy's vote. So first question, and this is, I think, when Katie was introducing this, one that reminded me, I think many people think about this in terms of the broader issues of corporate personhood. Can corporations be people, citizens united, all that. So, but the first set of questions involve whether the fact that we're dealing with a for-profit corporation is relevant to the outcome here. And it could be for many reasons, and the court runs through them all. Because RIFRA says the government shall not substantially burden a person's exercise of religion. How does a for-profit corporation exercise religion? Is it a person? So, and there are other questions I don't have time to even list. But in the end, the court answers it by saying that the owners of closely held corporations are the relevant people here. And they can exercise religion, obviously, they're biological people. And they have not forfeited their right, they have not forfeited RIFRA protection when they decided to organize their business as a for-profit corporation. And they talk about the right to run their businesses in the manner required by their religious beliefs. So I just want to mention for this point, it is limited to closely held corporations. They say we're not opining about public traded corporations, but slightly more than 50% of corporations are closely held corporations, so it's not a small subset. They do employ far less than 50% though, because they're small generally. Okay, second, I'm move more quickly here, is the exercise of religion at issue here substantially burdened? And the court, 5 justices say yes, and I could say many things about why I disagree with that particular piece of this, but I won't. Okay, don't have time. So we can ask about that if you like. So now, my brief, which I brought, this is the brief I filed, dealt some with the substantial burden, but even more with the next part of the analysis. Does the government have a compelling interest here? Because remember, if the government has a compelling interest and is using a means that's the least restrictive alternative of furthering that, then the government may substantially burden the free exercise of religion in this way. And so the brief that I wrote was primarily aimed at educating the court and generally explaining why contraception is important to women in all kinds of ways. So I was gratified by the fact that the majority didn't disagree with that. It didn't say anything positive about it either, though. It didn't acknowledge it. It just assumed without deciding that the government had a compelling interest in enabling women to access their method of contraception of choice. The dissent, though, cited it, so that was fun, but only 4 justices there. And I just, as a public service announcement, kind of like my Wikipedia warning, will share one of the many facts in here. The hormonal IUD is 45 times more effective than oral contraception, and 90 times more effective than male condoms based on typical use. So you may want to keep that in mind.
With fall break coming up.
Yeah. I told my teenage sons this. Didn't make them read the whole brief, but I did share that. The other thing that I'll say we emphasize in here is you have to think about women who are struggling to survive on minimum wage, and the dissent did cite the fact that a woman who earns minimum wage working full-time has to pay a month's salary for an IUD, very high upfront costs, and the dissent did refer to that fact. Finally, and then I'll turn it over to my colleagues here very shortly. Well, the fourth point is this the least restrictive alternative? And so here the court said no. The government has not used the least restrictive alternative, and therefore Hobby Lobby wins, and Professor Konkel is going to explain that in far greater detail. And I'll leave it to you also to explain what the government did in response. And 3 days after the Wheaton College ruling, does that sound okay? I was going to say something about it, but I'll leave that to you. Okay. Now I do want to mention 2 more points quickly. What are the implications of this beyond contraceptive coverage? Nobody knows. I mean, it is something that Professor Sanders will talk about in the context of how about anti-discrimination laws, laws that protect against discrimination, all kinds of discrimination. The majority opinion does say straight out that laws that protect against race discrimination, that is a compelling governmental interest. Doesn't mention sex discrimination or sexual orientation discrimination, and all kinds of open issues there. Also want to mention that there's a federal bill called Not My Boss's Business Act that has the support of 57 senators already, 57 senators, but you need 60 in the Senate, not 50, to get many things done. So they don't have, they need 3 more votes to withstand the filibuster, and then of course the House is even harder. And then the last thing I want to say is, although the majority and Justice Kennedy emphasized the narrowness of the holding, the dissent starts out by saying this is a decision of startling breadth, because it, how do you actually narrow this requirement of a very stringent test of compelling interest and least restrictive alternative? And the last thing I'll say is 2 weeks ago, a district court in Utah, and I'm just going to stay away from the anti-discrimination context, but said in a completely different context, cited the Hobby Lobby decision to say that a member of a fundamentalist offshoot of the Mormon faith could refuse to comply with a federal subpoena in a child labor investigation by the federal government, where the federal government is investigating children, very young children being forced to work in the fields rather than go to school. That's the allegation. And so this leader of this Mormon, it's a fundamentalist offshoot of the Mormon faith, says that it would violate a substantial burden on his religious beliefs to have to testify against his own faith. And a district court judge cited Hobby Lobby to uphold that. And now I will turn it over to Professor Konkel.
Okay. I want to zero in on sort of the substantial burden issue and the nature of that claim, which is really a big part of the controversy in Hobby Lobby, along with the claim on behalf of a property corporation. And that substantial burden issue then comes up likewise with respect to nonprofit organizations who are making similar sorts of claims, or did make similar sorts of claims, including Notre Dame, most notably in the state of Indiana. But one thing that's worth noting, and it comes out in Hobby Lobby, and it comes up in subsequent issues in terms of nonprofits, is the Affordable Care Act, when the government adopted the regulations, basically for the contraception coverage, it provided for 2 exemptions. One of them was a complete exemption for quote-unquote churches, which is not limited to Protestant churches or Catholic churches. It includes any religious body as defined in the tax code, and basically they are categorically exempt. That is a worshiping body, basically church, synagogue, mosque. They are categorically exempt. They don't have to do anything. They don't have to provide the contraceptive coverage to their employees. The second exemption, which is became controversial itself, was described as an accommodation that, after a lot of pushing and shoving back and forth administratively, the Obama administration crafted for the benefit of religious nonprofits that were not churches. So you're talking about Catholic charities, you're talking about religiously oriented colleges, and charities essentially. And with respect to those religious objectors, the government says you can be exempted likewise, but we've got a kind of a complicated process, maybe not that complicated. You fill out a form, Form 700, and Form 700 says we object to providing contraceptive coverage. You take that form, you give it to your insurance company, and your insurance company at that point does not provide contraception coverage through the basic employer plan. Instead, though, it provides that coverage separately, directly to the employees, without charge either to the employees, which is what the ACA requires, nor with charge to the companies, or in this case I should say the nonprofit religious organizations. They don't have to pay anything for that separate contraception coverage either. The government's theory being that the insurance company's going to save money because you're going to have fewer pregnancies and the contraception coverage is cheaper, so we can force the insurance companies to provide the coverage independently, more or less on their own, and they're going to end up saving money. So that's the accommodation for the religious nonprofits. Okay, when the Supreme Court decides Hobby Lobby, when it gets to the least restrictive means element of the case, says that, well, there's a least restrictive means to provide contraception coverage to employees, even for profit-making companies like Hobby Lobby. It's the nonprofit exemption. The government's already created it. So Hobby Lobby can fill out the form, send it, give it to an insurance company. Insurance company can provide the coverage. The employees get the coverage. The employer doesn't have to provide the coverage directly, and everybody should be happy. Of course, nobody's happy, I guess, in this context, and can be happy. That's one issue I want to get back to, is whether there are potential win-win solutions where you don't have to have winner-take-all kinds of political combat. In any event, the Supreme Court says in deciding Hobby Lobby, one reason why the contraception mandate is unconstitutional, I should say, violates RIFRA, as applied to the profit-making company, is the government can provide the same coverage through the nonprofit exemption, extend that to profit-making closely held businesses, and basically you don't need to require the company to provide the coverage directly through the employer plan. Okay, the nonprofit, though, issue is still percolating even while Hobby Lobby itself is being litigated in the Supreme Court. Basically because some religious nonprofits, including Notre Dame University, have said, as to us as a religious nonprofit, the accommodation is problematic. We don't want to fill out this form and give it to our insurance company, and this gets back to substantial burden, because that itself makes us complicit in involvement in a practice, the use of contraceptives, or at least some sorts of contraceptives, in a way that we think violates our religious faith. So basically the claim of Hobby Lobby is complicity in providing the insurance coverage. The claim of some religious nonprofits is even filling out the form amounts to improper complicity. The Supreme Court in Hobby Lobby, well, the dissent of Justice Ginsberg says that's not a substantial burden. It's too attenuated for you to say we object to providing insurance coverage for that an employee might use to do something that we object to. The majority says it's not our business to inquire into theological principles. And it cites for that proposition a case from the state of Indiana. A case, Thomas, I should say, versus Review Board, an older free exercise case where Eddie Thomas, Jehovah's Witness, says, I'm willing to work to fabricate steel in my company, even if that steel ends up being used for military equipment. But he gets transferred to directly making turrets for tanks. And he says, I can't do that. And I have to quit my job. If you're going to keep me in that department, I want unemployment compensation. The Supreme Court says, yeah, you can make that claim. It's up to you to decide what is too close to involvement that you regard as religiously permissible. That's up to you. That's the ruling the majority makes in Hobby Lobby. It's up to you to decide what your religion requires, and if you're going to get punished by the government through financial penalties. That's the substantial burden. We don't get into issues of theological concern as to how much complicity is too much. That's up to the religious leader itself. Back to the nonprofits. The nonprofits are saying filling out the form is a problem for us, especially when we're required to give it to the third party insurance company, arguably writing a permission slip you provide the coverage. We think that's problematic, even if we're not providing it directly through our insurance company. Okay, that claim basically gets litigated before the Seventh Circuit. The Seventh Circuit says in the Notre Dame case, that's not a substantial burden. Judge Posner writes the opinion, basically saying that the accommodation is perfectly fine, it's adequate, you don't have a substantial burden merely by filling out this form. Posner says it only takes you 5 minutes, and basically that should not be regarded as complicity, because it's the law that requires the insurance company to provide the insurance company insurance coverage. If you file the form, you're not really ordering your insurance company to provide the coverage, and therefore, whatever you may think about it, that shouldn't count as a substantial burden, and therefore the accommodation, at least, should not be regarded as a violation of the Religious Freedom Restoration Act. The Seventh Circuit did not take a hint that, in hindsight, was telling from the Supreme Court in a separate case, notably styled Little Sisters of the Poor versus Sebelius. Okay, so this is the Obama administration against Little Sisters of the Poor. Little Sisters of the Poor win temporary relief on December 31st from Justice Sotomayor, who later dissents vehemently in the follow-up case to Hobby Lobby involving Wheaton College. But the Supreme Court itself, in January, while Hobby Lobby is still being argued, issues an interim order saying that for Little Sisters of the Poor, at least, all you have to do is, in fact, send a letter to the government. If you send a letter to the government, you don't have to fill out the form, and you're still going to be released from having to provide the contraception coverage through your insurance practice. There are complications with Little Sisters. We can get back to that, but I don't want to take too much more time dealing with the Little Sisters part of the equation, except to say the Seventh Circuit saw that order from the Supreme Court. It was an interim order. The Seventh Circuit said, that's a special case. We still think Notre Dame has not suffered a substantial burden. Therefore, it loses in terms of the RIFRA claim that it is, in fact, asserting. Okay, ultimately, you get Hobby Lobby decided on June 30th, emphasizing that there's this nonprofit accommodation in place, which is a good reason, the majority says, not to, in fact, require a company like Hobby Lobby to directly provide the insurance coverage. You can use the accommodation provision that already has been established for nonprofits, simply send it to profit-making organizations. Meanwhile, Notre Dame and other nonprofits are saying, that's not an adequate accommodation. That still is burdening our religious practice, and the question is whether the religious nonprofit accommodation is or is not itself adequate. Okay, Seventh Circuit, on the same day Hobby Lobby is decided in a case involving Wheaton College, another religious, that's a nonprofit religious college in Illinois. The Seventh Circuit said, based on Hobby Lobby and based on our earlier decision in the Notre Dame case, we reject preliminary relief for Wheaton College. The accommodation is adequate. You can't say you're burdened simply by filling out the form. The same day, the Supreme Court says, wait a minute, we're not so sure about that. We want more briefing, and you have emergency papers filed in the Supreme Court. 3 days after Hobby Lobby, the Supreme Court issues an order in Wheaton College, basically, still theoretically as a matter of interim relief, telling the Seventh Circuit you're wrong, and in fact, it will basically do for Wheaton College the same thing we did for Little Sisters, which is basically that it will be enough if you write a letter to the government, rather than filling out the form if you think that, in fact, makes you complicit. The remaining issue, and I'll shut up here in a second, the remaining issue is what if a religious body, for that matter, even a profit-making company, objects even to sending the letter to the government, saying that that's still making me complicit. That issue is still kicking around. But basically what the Obama administration has done in response to Hobby Lobby combined with Wheaton College is basically issue new regulations saying that with respect to religious nonprofits and with respect to closely held corporations that have religious objections to the contraception mandate, send us a letter. Basically what the Supreme Court has suggested with the combined effect of Hobby Lobby and Wheaton College, send us a letter. and then presumably the government's going to have to find out who the insurance company is, provide the insurance coverage directly by telling the insurance company, you're going to have to provide this insurance coverage. It's not going to be provided directly through the employer. But again, this could be, at the end of the day, a win-win solution if, in fact, employees get the contraception coverage, if the religious objectors are, in fact, accommodated. Maybe you should think of that, or at least think of that potentially, as being a win-win solution that everyone, in fact, perhaps ought to be happy with. Okay, I'll leave it at that.
Could I just add
Sure.
though, but my understanding is all 20 of the parties objecting to filling out the form have said sending a letter to the government also violates.
That's going to be a problem.
They've all taken that position.
Well, Wheaton College
I
had
thought.
already written the letter. So is Wheaton College backing away from that? They wrote the letter.
I just called
Yeah.
a friend who's monitoring all
Okay,
that,
yeah.
and so I know that
Yeah.
my understanding is 20 parties, plaintiffs have been asked, and they have all said, even sending the letter.
And Notre
would make us
Dame,
complicit.
in the Notre Dame case, asserted an oral argument that
That
it would
it
not,
was.
they did not want to send the
Do
letter.
we want to send
I
the
think
letter?
if
So
you know,
it's
there,
interesting.
that's going to be, that would be a problem. I mean, basically, I think then if you can't even
Can't even
advise
send
the
a letter.
government of your objection, then I think that becomes, undoable, basically, as a solution.
Okay. So Professor Konkel, earlier in his remarks, was talking about the difficulty of this, and I think you said to him, no one is happy, no one can be happy with this litigation. And I want to take that as my point of departure in my remarks. I see the Hobby Lobby decision, the reaction to it by LGBT rights groups, which I'll talk about, as symptomatic of a hardening of positions in various ways that may not be healthy for the Supreme Court, for constitutional law, for religious liberty, or for LGBT rights. First, the opinion itself. I don't know how many of you have actually read the Hobby Lobby set of opinions, and I'm not going to go into them in detail. I guess to my mind, both the Alito majority opinion and the Ginsberg dissent are absolutely convinced of the rightness of their own positions. It's sort of all or nothing. You know, we're so this is just so obviously right, and the dissent is so obviously wrong. Or I'm so obviously right, and the court is so obviously wrong. They project the certitude of litigators representing their clients. It's more debatable whether either opinion projects the sort of wisdom we want to see from our high constitutional court. Neither opinion is as absolutely right as its posturing would suggest. I think the dissent, Justice Ginsburg, has the better of the argument. I think that Justice Alito's opinion has some fundamental flaws, some weaknesses that it doesn't acknowledge. First thing I learned on the first day of corporations is we have this thing called a corporate veil, and that corporations form to protect themselves from liability, and there's a fundamental wall of distinction, a difference between the owners and the corporation. Justice Alito makes some interesting points about how that's not as totally impermeable or as obvious as it seems. Corporations have Fourth Amendment rights and other things that protect persons, but he sort of never deals with how we can have a one-way corporate veil, how you can, if the owners of Hobby Lobby, if Hobby Lobby ever goes bankrupt, the owners of Hobby Lobby are going to stand behind the corporate veil. They're not going to say, okay, this was our corporation, we're going to use our own assets to bail it out. No, they're going to stand behind the corporate veil, the same corporate veil that doesn't exist when it comes to the religious identity being transmuted from the owners to the corporation. Well, that's getting off on a tangent. I think that both opinions are interesting because of the sort of hardness and uncompromising nature of the positions they stake out. Justice Kennedy is a little more wishy-washy, as is typical of Justice Kennedy. He sort of wants to be the accommodator and sort of see, well, the dissents, the respectful dissent has some interesting points. This is a narrow decision, blah, blah, blah. Okay, what does this have to do with gay rights? It's important to realize that Hobby Lobby was about RIFRA, as Professor Johnsen said. None of this applies to state-level gay rights laws at this point. Under Employment Division versus Smith, there is no heightened scrutiny for neutral rules of general application like sexual orientation non-discrimination laws in the 20-some states that have them. there is no viable claim that those impinge on your religious liberty, at least under the Constitution there is not, and courts have consistently rejected those claims. At the federal level, we don't yet have an Employment Non-Discrimination Act. There is no federal legislation that prevents any employer from discriminating on the basis of sexual orientation. It's important to know that. ENDA has passed the Senate, it hasn't passed the House, and is obviously not going to pass the House anytime soon. So the question of whether a private company like Hobby Lobby could get a pass from a federal law against employment discrimination protecting gays and lesbians or transgendered individuals is completely hypothetical at this point. Doctrinally, the question would be, does the government have a compelling interest in such a law, in protecting against such discrimination, and is such a law narrowly tailored enough to advance the government's interest in protecting against the evils of discrimination on the basis of sexual orientation or gender identity? Those are highly manipulable tests, and the court might be able to find a way to say, no, the interest isn't so compelling there, or it's not narrowly tailored. But again, the point I want to emphasize, this is all sort of hypothetical at this point. ENDA, the legislation sitting in Congress, not currently going anywhere, does have a religious exemption. But it is not a Hobby Lobby style religious exemption. It doesn't purport to allow completely private secular companies like Hobby Lobby to claim religious identity so that they would be exempted from the Employment Non-Discrimination Act. The religious exemption in ENDA is broader than the religious exemption in Title VII. Right now, a truly religious organization, a church, a religiously affiliated corporation, like a hospital or a school, does have a limited exemption from Title VII in that it can hire its own co-religionists. It is not a violation of Title VII for a Catholic hospital to say, we will prefer Catholic employees over non-Catholic employees. What a religious employer or religious corporation cannot do is to say it is against our religion to hire someone with this particular religious identity, or a black person, or a Muslim, or a person that one of the protected categories implicates that organization's moral views. It doesn't get a pass there. ENDA would allow a religious corporation, a church, a hospital, a school, to simply say it violates the tenets of our religion to hire a person who is gay or transgender. So that is a broader religious exemption than is in the other federal civil rights laws. I'm not sure it is a sweeping religious exemption the way it's been characterized. Okay, so again, why is this relevant now? Well, in the wake of Hobby Lobby and in the wake of the Wheaton College decision, major gay rights groups at the national level, the ACLU, Lambda Legal, a number of transgender legal organizations, announced that they were pulling their support from ENDA because of the religious exemption that it has. Gay rights groups had previously agreed to this exemption as a sort of classic political compromise to bring conservatives and Republicans on board. It was, again, a classic political log rolling and compromise. Now they're reneging. Why? The exemption, as it's currently written in ENDA, doesn't exempt private corporations, doesn't give us Hobby Lobby. If the Religious Freedom Restoration Act applies to ENDA, and a future Supreme Court so holds, nothing in the language of ENDA will change that. So I guess to me it's hard, I'm struggling to make sense of why gay rights groups have said no more support for ENDA because it has this religious exemption in the wake of Hobby Lobby and Wheaton, when the religious exemptions are quite different, I think, in those two cases. So what explains this? Well, for several decades, gay rights and religion, or at least socially conservative religious groups, have been seen as incompatible, as enemies locked in a sort of almost a mortal combat. And in that fight, religion has tended to have the upper hand. But I think that's beginning to change. Religious arguments against same-sex marriage are clearly on the ropes and are being rejected consistently by courts. And advocates for same-sex marriage are engaging in what I've called a sort of strategy of shock and awe. You know, filing all these cases, piling up all these wins in the lower courts, not opposing cert. The losing states like Indiana are asking for cert at the Supreme Court, and the gay rights groups, the plaintiffs, are saying, bring it on. Yeah, we want cert too. We want to get to the Supreme Court. We're not going to oppose review of this decision where we won at the local level. So I think there's a certain amount, actually a large amount here, of just old-fashioned muscle flexing by LGBT groups, a group that's feeling its own growing power culturally and politically and legally through its success with same-sex marriage, and then looks at ENDA and what a conservative Supreme Court is doing on the religion issue and is sort of saying, we don't need to compromise anymore. You know, Hobby Lobby was an outrageous decision, then they add insult to injury by seeming to take away the narrow tailoring religious exemption that they said was okay in Hobby Lobby, and they said 3 days later wasn't okay in Wheaton College. My sense is many advocates for LGBT rights have a sort of sneaking suspicion that in many cases these religious exemptions will not be about pure, true, principled religious conscience. Maybe it was with Hobby Lobby. I'm making no judgment about the sincerity of the owners of Hobby Lobby and their belief, but in many cases this is just going, these religious exemptions are just going to become another front in the culture wars, an effort by religious conservatives to hold on to the cultural hegemony and deference that they have enjoyed, but which they see slipping away. And I think at an extreme, you see some of that if you watched any of the coverage of the Values Voters Conference in Washington about a week ago, the increasingly sort of hunkered down and paranoid and persecution complex rhetoric that we see out of the most conservative religious denominations and religious political activists. If I'm right about the stance that gay rights groups are taking about ENDA, you know, this may be bad for gay rights. There's a lot of evidence that evangelical religious groups have been moderating in their views on gay rights recently. Mainline religious groups are becoming bolder in their embrace of gay congregants and even of gay marriage. And so if gay rights groups are now seen as walking away from that table, that could set the cause of LGBT rights back. And so I sort of end where I began. I see all this as kind of a hardening of positions all around. At the court, the conservative majority is emboldened and seems to see not much need to compromise, even though, you know, it says the opinion is limited. I think the Hobby Lobby opinion is quite sort of take no prisoners. But on the same way, the moderates on the other side, led by Justice Ginsberg, are digging in as well. And on gay rights groups are feeling emboldened and no longer feeling a need to compromise, and that's making organized religious and social conservatives feel ever more desperate and sort of digging in on their view. So polarization in our current political culture is nothing new. Unfortunately, I think it explains some of what we're seeing here and some of the link between the Hobby Lobby decision and then this decision following hard on the heels of it by LGBT rights groups to say no more religious exemptions in federal non-discrimination law. We don't need to make that compromise any further.
All right, open it up for questions or your comments. Reactions.
Has anyone looked at the Hobby Lobby, I'm sure people have, but looked at it from a business perspective of what would be stopping any privately held corporation from just saying they don't, or they religiously don't support contraceptives in order to get the benefit of not having to pay for them? It would save them money, is it?
Well, you have to have, I mean, one condition is, to make a RIFRA claim, is that you have to have a sincerely held religious belief. So that's a potential check. You know, that you could say, well, if it's not sincere, then you can inquire. If it's not sincere, you can't make a claim. Beyond that, I mean, I don't think it's saving money. I mean, at least if the government's right, and Professor Johnson's brief talks about, one type of IUD is very expensive, maybe we both are, but of the challenge was in Hobby Lobby. But putting that point aside, the government at least is saying there is a saving of expense when you provide contraceptives. So an employer who provides contraception coverage, if the government is right, it's not costing the government anything, it's not costing the employer anything more. And then the other thing, sort of from a business standpoint, that I might suggest is that there is potentially a check, a sort of consumer check on assertions of religious claims that might be unpopular. So there may be people who are boycotting Hobby Lobby. There may be people who, in other words, if you are a business, you want to, from a profit-making standpoint, you want to attract clientele. You don't want to make, in other words, your business incentive, I think, would be not to assert controversial religious claims, which in fact, I would suggest, tend to suggest that these are probably sincerely held religious beliefs on the part of those who are objecting, because they may be hurting themselves. You know, it's an empirical question. Maybe they're going to attract conservative Christians. Let's go to Hobby Lobby and buy more Hobby Lobby supplies. But I think there is sort of a business check on the assertion of some of these claims.
I think it's true in this context, and even IUDs are expensive up front, but over time, pregnancy, just the medical costs associated with prenatal care and childbirth, very expensive and far more than contraception. But I think the harder question is other contexts. Though even in this context, I think the fact that everything, the government's tried a few things and said, okay, just send us a letter, and the religious beliefs of the plaintiffs and the theory changes. You know, nobody questions the sincerity of the beliefs of Hobby Lobby and the plaintiffs here, but it does seem a little bit like the lawyers are describing and maybe counseling about how to describe the religious beliefs, because whatever the government comes up with is a violation. You know, so of all, I was just talking to, as I said, a friend who monitors all these cases and writes extensively about it. And you know, I do think, and works with the government too, I think they are trying to come up with something, you know, some way of letting their religious objection just be known. And but the harder question is outside this context. What, like the Family Medical Leave Act is an example often raised. You know, what if an employer has a religious objection to same-sex marriages and child rearing by same-sex partners, and opposes you know, and wants to discriminate against transgender individuals, and wants to deny family medical leave required under federal law, saying RIFRA allows that because it offends my sincerely held religious beliefs. I guess that, you know, I can imagine circumstances where it's expensive for employers to give the benefit, where there could be that kind of incentive, but we just have no idea at this point, other than strict scrutiny, you know, compelling interest, research alternative would be the method of evaluating that claim, how any of it would come out. So it does clearly open, you know, can of worms and whatever kind of.
The sincerity inquiry sometimes is affected by whether there is an alternative non-religious motivation. So that, you know, you get claims of prisoners saying, you know, my religion requires me to have sirloin steak and lobster, you know, 3 times a week. Okay, there are other non-religious reasons that a person might make that claim. Likewise, if you're going to save a lot of money, you know, that could contribute to a claim that this is really not a sincere assertion. But it doesn't mean you can't make the claim.
Yes.
I'm curious as to, I guess, all of your guys' opinions, but especially Professor Konkel, as to whether the question that you posed, what if the religious body objects even to the letter, if we will have a decision on that, or if it will just continue to get tossed around?
I think especially if you read Kennedy's concurrence, I think the objection to sending the letter is going to lose. I do. I mean, I think the Supreme Court has basically crafted the compromise in Wheaton College that even though it's an interim ruling, I think that's the compromise the Supreme Court is basically going. I could be proven wrong. And maybe some of these objectors to writing letters, but I really don't think so. I mean, I think that the idea that you have to assert and inform the government of your religious objection is essential to the assertion of a claim. So, in any event, I think the Supreme Court has basically painted the picture that it's planning to paint, and that's the compromise. And if so, then I think maybe we shouldn't be, angry, and we should be saying, yeah, this is a compromise. It's working out. We have religious pluralism. We also have women getting contraception coverage. It's a bit more cumbersome. It's going to cost the government some money to do the alternative administrative scheme, but presumably it'll work.
I had a question about, when it comes to the question of sincerely held beliefs, I was wondering for the federal RIFRA statute, if there's a necessity to be part of an identified religious organization or religious group. I know for some of the mini RIFRAs, like Florida's RIFRA says that religious beliefs are protected even if it's not part of a larger system of beliefs, right? You can essentially be a religion of one person. Is that also true for the federal statute, or do you have to sort of be part of, you have to say, well, this is a Catholic belief or this is a Mormon belief?
No, well, at least basically RIFRA, sort of the Religious Freedom Restoration Act, is designed to mostly pick up what the Supreme Court earlier had said in free exercise doctrine. And at least in that free exercise doctrine, the Supreme Court had made it pretty clear, well, it's somewhat ambiguous what counts as religious. Maybe somewhat, I should take away that word. It's ambiguous at the margin of whether a claim is religious as opposed to something else. If you have a spiritual belief, I'm a vegetarian, I don't believe in God, you can get close issues. But if it's religious, even if you are, not a part of a group that believes as you do, the Supreme Court earlier had said you're protected, and I think that would still carry over. So there was a case where someone personally read the Bible to require absolute non-work on the Sabbath, but his church didn't subscribe to that. The Supreme Court says, well, you subscribe to it, it's biblically based, it's religious, you're protected.
Other questions or comments? Yes.
In an interview, I think it came out last week, with Justice Ginsberg, she said she thinks this is the most conservative we'll get with anti-abortion decisions and pro-choice cases. So I was wondering what you thought with your past experience, if you share her optimism, or do you think things will get worse before they get better? And then also how the pro-choice movement should proceed, like state by state, like the same sex, or should we push this not my boss's business bill?
All right, so I don't know where we are really at the moment with the Supreme Court in terms of how they will rule on something like, she referenced the Texas law that is an admitting privileges requirement that's shutting down most of the clinics in Texas, and so that's a really important, next case to see how the court will rule in a case like that. But I'm not optimistic, and Justice Kennedy will be the deciding vote. And whether it gets worse depends on who's elected president next, to be blunt. It's really on this issue quite predictable, I think, or has been in the last decades, how justices will vote. So I think in terms of Hobby Lobby, so many issues are 5-4 now. I mean, the court is sharply, Citizens United, so much depends on who is appointed next to the court on this and many issues. In Hobby Lobby itself, and Not My Boss's Business Act, looks hopeless in the House now, but depends, who's elected to Congress. That would just address this particular application, and frankly, I'm worried about the anti-discrimination laws that don't involve race, and things like family medical leave. Not so much vaccinations, other medical procedures that the court, I think, would say compelling need to include those. But just, so much is up in the air on all aspects.
Just a footnote on that. Notice that the way the RIFRA is structured, it says that RIFRA applies to any, this was passed in 1993, any pre-existing federal law and any future federal law unless the new law explicitly says otherwise. So the proposal that Professor Johnson is talking about would basically say this law applies without regard to RIFRA, which would be the first time Congress has ever sort of trumped RIFRA by saying that we're going to create an exception. And it's sort of advocates for RIFRA back in 1993, which was almost universally supported, were basically saying, you know, we want to deal with this globally, not with specific exemptions for specific areas. And then I think, basically, as Professor Sanders was suggesting, largely the gay rights movement got the question presented, do we really want RIFRA applying across the board? Do we want to have civil rights exceptions? And if there's an exception for the contraception coverage, you know, that would be maybe one of potentially many. And RIFRA could get eaten away over the years depending on how things transpire.
This one behind the pole there. Oh, yes.
I guess I was curious how going forward the court is going to balance the provision of RIFRA that prohibits the government from mandating any kind of action that substantially burdens religion with this kind of deference towards individuals in terms of what they consider a substantial burden is. How does the court kind of like weigh each of those?
Well, I think that the one thing Hobby Lobby teaches is, you know, it teaches in terms of what the governing law is that the Supreme Court seems to be incredibly deferential to the definition of a religious belief. In other words, if you as an individual or a nonprofit religious entity, or even as a closely held corporation, if you believe that a particular government regulation substantially impairs your religious faith, you're in the door under RIFRA. So really, in that sense, the decision is quite broad in sort of opening up the door. Then the whole ballgame turns to compelling interest, least restrictive means. And whether or not, for example, in the context of discrimination, the Supreme Court could say that in the context of discrimination, there simply is no viable alternative but to simply prohibit it without exception, at least in the context of the profit-making corporate world. But I think that's where, you know, unless you and then it's exceedingly difficult conceptually or theoretically to come up with any substantive evaluation of substantial burden. You know, you do get into theological issues, and you want courts deciding when you know, an individual or a company is too complicit, what counts as complicity. Really difficult. Much easier to go the route the majority went, which is saying if you got to pay a big fine and you think it violates your religion, that's a substantial burden, and then we'll deal with it on the compelling interest, least restrictive means side.
We have time for one more. Yes.
Yeah, going forward, this point about the implications of Hobby Lobby for any discrimination laws. So, for example, let's say in the wake of Hobby Lobby, you know, RIFRA would be triggered by application of Title VII to a closely held for-profit corporation. The court mentions that the discrimination targeting race, laws that prohibit discrimination targeting race might survive sort of a compelling interest standard. What about you know, other bases for discrimination? I mean, is it appropriate to draw, for example?
I think Professor Johnson said it. We don't know, right? It's an open question. So Title VII, of course, doesn't apply to LGBT rights, to sexual orientation. Right. That's why we have ENDA. You know, there's already, you can already discriminate against non-members of your own religion under Title VII if you're a religious corporation. But yeah, I mean, I think Hobby Lobby is one of those decisions that, you know, it says it is narrow, it's only applying to closely held corporations, yet the logic of its legal reasoning, it's not clear why it couldn't apply much more broadly to larger corporations or to other kinds of laws. I mean, you know, that's the conservative argument about Lawrence versus Texas, right? It's really very sweeping, even though it pretends to be narrowly cabined. This is kind of the opposite of that. I think it's potentially a very sweeping law that only time will tell.
How many publicly held corporations are going to be identified with a religious identity like Hobby Lobby and like Conestoga Wood in their original corporate documents? Mm-hmm. It says, you know, we are going to follow the Lord in everything that we do in this business. All the family members sign up. You get 5 family members. that own Hobby Lobby, 5 family members own Conestoga Wood. That's not IBM, that's not Microsoft.
But what about Chick-fil-A, which is kind of in between, right?
Chick-fil-A.
Chick-fil-A is an
Yeah,
IBM,
yeah,
but it's also
yeah,
not Conestoga Wood, it's a
Is it
big,
publicly traded?
I don't think so, I think it's privately held, but it's a big,
Hobby Lobby's
prominent.
Hobby
big,
Lobby's big
Yeah.
too.
but
yeah.
owned by a few. So
I think it
yeah.
clearly applies to Title VII though, right? I mean, I think that you couldn't argue that it does not. And it brings to mind,
You mean RIFRA applies?
yeah,
RIFRA applies to any
to
federal law. RIFRA applies to any
FMLA,
federal law.
Title
Doesn't
VII,
mean you're gonna
Title
win.
IX,
Yeah.
but you're subjected to, compelling interest. And just to throw out one other case that Professor Konkel and I were talking about, that the Indiana case, in this case it was a Catholic school fired a woman for undergoing in vitro fertilization with her husband. And in that case, the court, is a Title VII claim, upheld the right of the church to do this if it was not sex discrimination, but instead was because she was acting against the teachings of the church. And if they raised the question, would they have done this to a man, to her husband if he had happened to be working there? I haven't actually read the opinion, but is that essentially right? That's just another context in which this kind of thing could come up, where, women engaging in some other kind of activity, assisted reproductive technology, for example, could go against the employer's religious beliefs and could be fired for that. Or at least subject to the compelling interest, Lisa should give an alternative example.
I guess I know we're out of time. I don't know if
Yeah.
Dan has a final comment. This is a court, I think, broadly. I think you see this in Hobby Lobby. I think you see it in the Town of Greece case. This is also a court that is very sympathetic to public religion, public expressions of religion, to religiosity in public life as well as private life. What we've seen so far is all of those contexts are sort of majoritarian religion. I wonder if Hobby Lobby would have come out the same way if it was a group of Zoroastrians or something like that.
Well,
If it was a minority.
I don't know if
religion.
that's entirely true. I mean, there is the first significant application of RIFRA was not Hobby Lobby, but a case called Gonzalez that protected the rights of a tiny Brazilian sect to drink hallucinogenic tea unanimously.
Right.
The Supreme Court protects that. So
I think the court has become a little bit
Could be.
more,
Yeah.
since the departure of
We
Justice
have this
Konkel.
And then the
case
other-
out of Utah now, we'll see how that
Well, there's
goes.
the case out of Utah. The other case that Hobby Lobby has played a role in is a case protecting Native Americans from an eagle protection statute.
Yeah.
Okay, well, I think it remains to be seen whether this is sort of skewed in one direction or another in terms of the doctrine that's going to emerge. But
All right, we'll have to leave it there. Thank
Thank
you.